SJC-12175, Sandra R. Edwards v. Deval Patrick.
Mr. Pino, good morning.
Good morning, Your Honors. May it please the Court, Michael Pino on behalf of former Governor Deval Patrick. Governor Patrick's absolute privilege argument is based on two public policy considerations. One, that it is important to the public interest that the governor feel free to speak candidly on matters of public importance. And two, that the prospect of being sued for defamation inhibits that candor. On the basis of those same two policy considerations, the United States Supreme Court has found an absolute privilege against defamation claims against federal officials. The Restatement Second of Torts has recommended absolute privilege for governors and cabinet-level state officials as well. And the majority of state courts to consider that question have followed suit and adopted an absolute privilege against defamation claims for governors and cabinet-level state officials.
I understand that Mulgrew says we don't have to decide this question, but when you read that and you read Vigoda, don't you think we sort of have decided it?
I think the court...
Against your view?
I think the court has observed several times that absolute privilege is something that it adopts sparingly. So to the extent it has sent perhaps a signal, that is the signal that it has sent. So I can see that, but the court has stopped short, and I think appropriately so, from having decided the question because it hasn't needed to in the cases where it's arisen. It has instead gone to the alternative, the constitutional qualified privilege, and found on that basis. So I do think that the issue is open.
Here, do you think we have to decide it?
I do not, Your Honor, because I think that we have a prevailing constitutional and qualified privilege argument as well. But in the event that the court is not persuaded by that constitutional privilege argument, then it would need to decide the absolute privilege argument, and it has not up till now.
Now, of course, the problem with the absolute privilege argument is that it's absolute. So what if we had a governor who had no respect for the truth and who in a situation like this said, I fired her because we found child porn in her computer? Totally false, absolutely defamatory. Under your regime, no remedy.
Correct, Your Honor. And that is the countervailing policy consideration, that a plaintiff would have no recourse in the event the court adopted absolute privilege, even for an absolutely defamatory statement. That is the countervailing policy consideration, and it has been wrestled with by the courts that have adopted absolute privilege. They have acknowledged it, but they also have acknowledged the countervailing consideration, which is that the importance to an informed citizenry, the importance to the effective functioning of a democracy, for chief executives to feel free, uninhibited, to speak candidly on matters of public importance. In this case...
The obvious question, I guess, is why doesn't the qualified privilege do that? Nobody wants to chill discourse, I hope, and we do need the free flow of ideas, but the qualified privilege, I mean, take this case, for instance, even assuming the governor did not know the chronology and the details of the Paglia lawsuit. He's protected as long as the activity is not reckless disregard for the truth.
I agree, Your Honor, that the constitutional and the qualified privilege are vigorous privileges. They are powerful privileges, but the protection that they afford is not as extensive as absolute privilege. And the main distinction in why the absence of an absolute privilege might still impede candid speech on the part of a governor is because of the impact of having to defend the lawsuit in the first instance.
Well, that's a good point. No doubt that that's a good point. It's not whether the lawsuit succeeds that could chill debate. It's the fact that there could be a lawsuit every time you go out and speak to the press. But according to the plaintiffs, that's happened about 3 times in our history.
Well, the plaintiff's statistics are specific to Massachusetts, and they are specific to public decisions in Massachusetts. So I do not know, prior to the time when, for instance, Superior Court decisions, they're now available in Westlaw, unknown how many Superior Court decisions might exist. But that's really, I would submit that's almost beside the point for a couple of reasons. One, the plaintiff does cite in her brief to this court well over 50 decisions across the country of public officials at all levels being sued for defamation. So it's not.
So how far would your absolute privilege go? Which public officials would it cover? Would it cover all of the legislature as well as all of the executive branch?
At this point, Your Honor, we're simply asking the court limit itself to the governor.
Well, so it's an absolute privilege just for the governor, not for the lieutenant governor.
Well, that's what we're seeking, Your
Question
Honor, because
is-
that's what this case presents. But it's a fair question, and the dividing line that the restatement has drawn and that many courts have drawn, state courts have drawn, is between the governor and lieutenant governor in cabinet-level executive office positions and everyone else.
What about
That's-
the legislature?
The legislature there is an absolute privilege already in the legislative setting and also in the judicial setting for the same two policy considerations, and that's really the point that we make. Is there a distinction in this court's mind between the force of those public policy considerations in the gubernatorial setting and the force of those same two policy considerations in the judicial and the legislative setting? The same countervailing considerations exist in both settings.
What about a legislator that speaks to the press outside the House chamber?
Your Honor, I'm familiar with the cases that speak to formal legislative settings, so committee hearings where someone is testifying. I can't recall if this court has addressed that situation, but it has in the judicial setting. There is a case, Mazzullo versus Mallets, which we cite, that involved an out-of-court statement in a judicial setting. It was a witness competency certificate signed by a physician who, from the record, never testified in court. And the court held that the absolute privilege did encompass that. So my brother's point, which is that there are reputational safeguards, the adversarial process in the judicial setting, that has not been the basis on which this court has adopted absolute privilege.
Without getting into the weeds in your actual malice argument, just thinking about the enormous power of the governor, and the governor's outside of his office, he's talking to the press. It's on a personnel matter. The person who's impacted is almost undoubtedly not there. And the statements that come out of his or her mouth could professionally and personally destroy somebody. Isn't qualified privilege enough so that that person whose life could be destroyed by somebody in an incredibly powerful position, isn't that enough?
Your Honor, I would submit no, because of the chill of just having to defend the lawsuit in the first instance. And this case demonstrates that. Governor Patrick has not been in office for over 2 years, and he still has the specter of this lawsuit and the need to defend it hanging over his head. Defamation is unique in that respect. It's a lawsuit against the governor in his individual capacity, and as a result, there's no substitution of parties when the governor leaves office. So having to defend is a chill in and of itself. But I would like to turn to qualified privilege because it is an important...
Can I just ask you one other question?
Sure.
The second press comments were after he left office?
Yes,
And
Your Honor.
but that you say that doesn't make any difference because he was talking about an action that had been taken while he was still governor.
Yes.
Is that right?
Yes.
But the second statement is not adorned with concerns about the SORB regulations, concerns about management. The second statement is just pure unadulterated comment about the plaintiff here and her performance and what she allegedly did.
From the context, it appears the governor was asked about the filing of this lawsuit, and he responded by largely hearkening back to the same comments he had made after removing Ms. Edwards in the first place.
Now, is it your view, I couldn't tell from your brief, is it your view that what the governor said on both occasions to be protected opinion as opposed to affirmative statements?
I thought about that long and hard, Chief Justice Gantz, and I think in fairness, there are elements of it that sound in fact, and there are elements that are opinion. So for instance, when the governor commented on the inappropriate pressuring of the hearing officer. That's a statement of opinion I would submit.
But it may be, there may be, I mean, it may fall into the category of undisclosed facts behind that opinion.
Correct, correct. So if I could turn to the constitutional privilege, actual malice is at the heart of the issue here. And the plaintiff's allegations on actual malice fall into three categories. Category one is conclusory assertions of knowing falsity. We've cited in our brief countless decisions holding that those are not sufficient, and the plaintiff does not seek to counter those cases. The second category of allegation is her allegations of vindictiveness and spite and ill will. Those also are legally insufficient. Actual malice in the context of defamation is different.
They're insufficient, sure, but they're in the complaint, and they go into the cake. They help thicken the proof. They're absolutely insufficient, but they're not irrelevant.
No, they're not irrelevant, Your Honor, but they are, at the pleading stage, insufficient standing alone to meet her
Absolutely.
burden of pleading actual malice.
Absolutely, but that's all that's in the complaint.
Well, that takes me to the third category, because there are three: the conclusory assertions, insufficient; ill will, insufficient standing alone. And if you look to our reply brief, I believe it's pages 18 to 19, we cite a series of both federal and state decisions holding that ill will without more is not sufficient to get over the bar. And then the third category is the alleged conversation she had with Kendra Foley at the time of her termination. And I would submit that's really the heart. Does that rise beyond speculation, and is it plausible under Yannicchino? And I would submit that it is not. First, actual malice is an individualized subjective test. It turns on the governor's state of mind, not on Ms. Foley's state of mind. So what she had to say or what she did not have to say is completely irrelevant to the governor's state of mind, unless the plaintiff alleges that it is the governor who told Ms. Foley to make that comment, and that comment actually reflected his state of mind.
Could I just ask you one factual question about that? Because I couldn't tell. There was the meeting called for September or whatever, 15th, and a bunch of people were in the room, including Ms. Foley and
Yes.
the governor and Ms. Edwards.
The governor was not in the room, Your Honor.
Ah.
He is not alleged to have been in the room, and I think that's probably a matter of undisputed fact, that he was not in
Okay,
the room.
I misunderstood that.
So is it your position that were Ms. Foley to say, the governor thinks you're doing a great job, but we're going in a different direction? It would have to have been something like that. There had to have been some information that came from the governor for it to be actionable?
Two things, Your Honor. First, there would need to be an allegation or a plausible non-speculative inference that the governor told Ms. Foley to make that comment. And two, that it actually reflected his state of mind. Because it's his state of mind that matters. It's only knowingly false if he says something that he believes to be untrue. So it's those 2 points. And if you look, there's no allegation that the governor told Ms. Foley to say that. No allegation that that actually reflected his state of mind, that you did nothing wrong comment. It's an inference that she asked this court to draw, and that's clear from her brief to this court. She wants the court to infer that the governor told Ms. Foley to make that comment, and to infer that the comment reflected the governor's state of mind.
Now,
That's a-
what do we know about what the governor knew that she was going to do? I mean, what was her position?
She was director of boards and commissions, Your Honor.
So was she sent in to basically fire?
I think that's an inference, and I think that's a plausible inference. I'm not sure it's alleged. It's certainly alleged that she informed the plaintiff that she was being removed from her position as
Did
SORB
do
chair.
that, and she
Yes.
did it presumably with someone's authority.
Yes, Your Honor. That's also a plausible
You
inference.
also say you serve at the pleasure of the governor?
That is alleged,
It's-
and it's legally accurate.
So on the Foley matter, we're at a motion to dismiss.
Correct.
And the question is there enough in the complaint, not taking Foley in a vacuum, to say, well, you may be right. That may not be an agency comment that inures to the detriment of the governor. That may absolutely be right. But we're at a dismissal, a complaint. We're not at summary judgment. And is that a fair inference, looking at the complaint in conjunction with everything else?
It is not, Your Honor. It's not for two reasons. One, It's speculation to infer that the governor told Ms. Foley to make that comment. There's nothing about that comment that's sufficiently unique to compel a reasonable inference that it only could have come from the mouth of the governor, as opposed to just an effort by Ms. Foley to soothe Ms. Edwards' feelings at a difficult situation. That's number one. Number two, it's implausible. It's implausible because it's implausible to believe that it would have reflected the governor's state of mind for two reasons. One, there's ample basis in the record to support the truth of what the governor had to say. There was indisputably a lawsuit filed by a hearing officer against Ms. Edwards alleging inappropriate influence. It's indisputable that lawsuit was settled. The governor gave other reasons involving SORB's failure to update his regulations. That's also undisputed. So it's implausible to believe the governor would have said she did nothing wrong for that reason. Second, and equally importantly, the plaintiff's own allegations of vindictiveness flow directly from the governor's statement that she had exerted unlawful, inappropriate pressure on a hearing officer. That goes to the heart of how she had discharged her duties as chair of SORB. So according to the plaintiff's own allegations, the governor absolutely believed she had done something wrong. She had sought to interfere with a hearing officer, much like the trial court administrator here, interfering with a superior court judge, trying to get that judge to alter a decision after a bench trial. It's the same type of allegation. That goes to the heart of how the plaintiff had discharged her duties. Given that's the plaintiff's own allegation, that the governor believed that, it's absolutely implausible to think he would have said to Ms. Foley that he didn't think Ms. Edwards had done anything wrong. He absolutely did believe it.
It didn't have to be true. He didn't have to have believed it. It could have been with reckless disregard for the truth.
Reckless disregard.
Have to believe it. It could have been, that's not necessarily true.
Reckless disregard is defined as someone stating something that they have strong reason to believe may not be true. And here, given the state of the record on the Paglia lawsuit and the allegations, and the plaintiff's own allegation that the governor believed she had inappropriately, or alleged she had inappropriately tried to interfere, how is it plausible to think he would have told Ms. Foley that Ms. Edwards had done nothing wrong? He acted out of a belief that she had done something wrong, according to the plaintiff's own allegations. So I recognize I'm about to run out of time, but the bottom line here is putting absolute privilege to the side. On constitutional privilege grounds, there have to be plausible, non-speculative allegations. Here there are none. There's just a request for an inference. Inferences have to be plausible and non-speculative as well. And all the plaintiff has put forth are conclusory assertions, not sufficient, spite and ill will, not sufficient standing alone, and allegations about Ms. Foley's comment, which speculate that the governor even said that to Ms. Foley, and further implausibly infer that he didn't believe it, which goes against the plaintiff's own allegations here. So for those reasons, we would argue, both on absolute privilege and constitutional privilege grounds, the Superior Court should have dismissed this with prejudice.
Thank you.
Thank you.
Mr. Sheehan, good morning.
Good morning. May it please the court. My name is William Sheehan. I represent the plaintiff Sandra Edwards. We turn first to the question of absolute privilege versus conditional privilege. The conditional privilege that we have in the Commonwealth strikes the proper balance among the three considerations that are key here. That is, the governor's ability to do his job, the public's right to know the truth, and the protection of an individual's good name. This court recognized that back in 1965 in the Vagoda case, a case that was decided after the Supreme Court case in Barr. And then in 1991, when it looked at the issue again in Mulgrew, again, it declined, in my view, properly, it declined to adopt the absolute privilege.
Well, it didn't reject it. It didn't, I take the opposite position that I took with Mr. Fennell, but the court didn't decide the question, said we don't need to, particularly in the latter case, the Mulgrew case.
It did not. It was reluctant to adopt it, and I would suggest it should be reluctant to adopt it still, because it does, the conditional privilege has the proper balance, because it does protect from liability a governor who is telling the truth or trying to tell the truth and simply mistaken. But it also protects, I'm sorry.
You know, here's the thing. What distinction would you draw in terms of policy considerations between the governor, the legislature, and the judiciary?
With respect to the
respect to an absolute privilege.
with respect to the legislature, the absolute privilege emanates from Article 21 of the Articles of the Constitution of Massachusetts. With respect to the judicial privilege, the absolute privilege arising out of, in judicial proceedings, arises out of the protections that the truth will be told in judicial proceedings. When you look at the cases, in particular the Ezekiel case finds comfort with the absolute privilege in judicial proceedings because there's a judge that calls the balls and strikes, and there's sworn testimony. The sworn testimony is also the underpinning for absolute immunity with respect to legislative committee settings. That is not the...
Because it's sworn testimony?
And that the...
When legislators speak, they're not sworn.
No, with respect to there's a case that was cited by the defendant that talks about testimony before legislative committees, which is also sworn testimony. The privilege that arises in the legislative setting is not based on the protections of being against pains and penalties of perjury. There it's found in Article 21 of our Constitution.
Which states what?
Article 21 says that because it's so important to have free debate in the legislature, that no action shall be commenced arising out of any statement made therein.
Counsel, would you have to, in your complaint, allege that what the governor said was not true?
And we have. We have said that at a number of different paragraphs. We've said it in paragraphs 52, 62, and 67, all of which label that statement as false. In addition...
Say that again, I'm sorry.
Yes. At paragraphs 52, 62, and 67, we label the statement that was made by the governor. We describe that as false. Also, with respect to what Sandra Edwards, what her interaction was with Mr. Paglia, and that it was not improperly pressuring him, but rather having discussion with him and ultimately taking certain remedial steps for the SORB in its entirety. Those details are found at paragraphs 38 through 42. So all of those things, together with the paragraph 44 allegation that at all times Sandra Edwards acted properly in carrying out her duties, all of those things would refute the suggestion that the statement made by Governor Patrick was true.
Okay, I'm trying to sort this out. Let's turn to paragraph 52. Which part of that statement is not true, that he did not that she did not engage in pressuring
Correct.
to change the outcome?
Well, that is the crux of our defamation case, that Governor Patrick accused the plaintiff of improperly pressuring a hearing officer, and that is not so.
Yeah, well, you can see that she did do various things in the complaint. She did seek to have him change his point of view, did she not?
No, she had a conversation with him about the notion of spousal rape being rape. The decision had already been announced, Your Honor.
Okay.
The decision was announced on August 31st of 2007, well before my client became the chairperson of the SORB.
Yeah, I'm
That
looking
was
at paragraph
November.
40. I'm looking at paragraph 40.
Yes.
Paglia asked the plaintiff to meet with him. Plaintiff began to discuss the Psy matter. He discussed the elements of rape, and your client told him that rape is rape and that the California spousal rape statute is like a statute to the Massachusetts rape statute. Does that not suggest that she was telling him that he had erred?
She may very well have been telling, she did tell him that she thought he had erred, but that's very different from trying to get him to change his decision.
Well, the governor simply said pressuring to change the outcome of a case. So you're saying that the knowing falsehood was that the governor mischaracterized what she was doing? That instead of her discussing with him the case and telling him that he erred, that the governor made a knowingly false statement to say that that was inappropriate pressuring?
telling someone after a decision has been made that, in her view, that decision was incorrect is very different from trying to get the hearing officer to make a decision before the decision is made.
Well, wasn't there pressure, I mean, didn't the agency, and maybe it was before she came, but refused to release the written decision, right?
There is no question that there are allegations from Mr. Paglia that people tried to pressure him into deciding that spousal rape was rape, and into deciding that Mr. Sy should have to register. All of that took place before Sandra Edwards was in the SORB. Sandra Edwards did not come to SORB until November 5, 2007.
Right,
The
but so
decision-
you have that pressure, and then she comes and she says spousal rape is rape. So isn't that just following up and repeating that? The pressure that was before?
The pressure, it's unduly influencing the hearing officer to come to a decision not based on evidence, but to come to a decision because of being pressured politically.
Was she involved in the decision to demote Mr. Paglia?
I believe that was an administrative decision, Your Honor. I do know that it was the decision of Ms. Edwards to have all hearing officers go through training. She definitely did that.
And adopted new rules or something about how decisions would be issued?
Correct.
Mr. Shan, can you explain to me how the Foley conversation is evidence of the governor's state of mind?
Yes. Since it's only the governor who can make the decision to terminate Ms. Edwards, the governor, acting through a person who was in charge of that area, if you will, the director of commissions and boards, someone, presumably the governor or someone acting immediately for the governor, told Ms. Foley what to do and gave Ms. Foley certain information.
I guess the second part of your answer is troubling when you say it could be the governor or someone other than the governor. Doesn't your inference have to be the governor?
It doesn't have to be the governor speaking directly to Ms. Foley, although I think that's a fair inference. But there could be an intermediate level. But it is a fair inference, I would suggest, at this stage of the proceedings, that Ms. Foley was repeating what the governor's position was. The governor's position was, according to Ms. Foley, that my client had done nothing wrong, but she served at the pleasure of the governor.
But what about the problem of agency? I mean, it's a personal tort here we're talking about.
It is, and I'm not suggesting that the governor, if he doesn't have the governor himself must have the mindset either of, with respect to the falsehood, he must be intentionally misstating something, making a false statement, or reckless disregard. And I agree, it is a subjective test, that it's the governor's state of mind. But the governor's state of mind in this case, at this stage, is fairly reflected, we suggest, by what Ms. Foley said, that it is a fair inference that Ms. Foley didn't make the decision to terminate Ms. Edwards, and Ms. Foley was the one who communicated that decision. Where did she get that information? Where did she learn that the governor wanted to terminate the employment of Ms. Edwards?
So we have to assume that, by your logic, that the governor said, I want to fire her, I want you to fire her, but she did nothing wrong. That would be the conversation as you understand it.
Because all of the position, because you take the conversation in its entirety, if you would, Your Honor. That is, the decision made to terminate, the statement that the governor had the right, the way it was quoted is, the governor had, that Ms. Edwards served at the pleasure of the governor. And when asked specifically, what did I do wrong? There was an answer from Ms. Foley. It was interesting. Ms. Foley didn't answer any other questions. Ms. Foley directed any other questions to Undersecretary McCroom, but Ms. Foley was comfortable in answering that question, saying, no, you did not commit any wrongdoing. I would suggest it is a fair inference that she was comfortable making that assertion, answering the question that way, because she had been told that. And the suggestion here is that that is a fair inference at this stage of the proceedings on a motion to dismiss.
Could we go back to the point I think Chief Justice Gantz was making? So why is the governor's statement reckless or in fact wrong? If he says that your client was attempting to interfere with the hearing officer. Now, clearly, when the hearing officer, Mr. Paglia, made the decision about Mr. Sy, your client didn't even have a job there.
Correct.
However, he was referencing the lawsuit that settled. I'm talking about the second statement. And that lawsuit that settled included a statement that Ms. Edwards had, once she got there, tried to change Mr. Paglia's mind and changed the decision. So why isn't that a statement that wouldn't qualify as defamatory?
The governor was not repeating the allegations that Mr. Paglia made. He did not say at either news conference, Mr. Paglia alleged such and such. The governor stated what Mr. Paglia had alleged as fact.
Well,
He
you
adopted,
assume that
in
from
essence,
you assume that because the case was settled, right? You assume that what Mr. Paglia said was true because the case was settled.
I don't assume that what Mr. Paglia said was true. All I was just trying to draw.
No, not you, but I mean, the governor was entitled to assume that. If the case is settled, and this is an allegation in the Paglia's lawsuit, then the governor would be warranted in assuming that they settled it because it was true, right?
The allegations of Mr. Paglia included far more than that Sandra Edwards.
No, I understand that. I'm just saying that the governor was entitled to say that this case was settled and this is what happened in addition to some other things that happened, the regulations and so forth and so on.
If all the governor had said was that the Paglia case settled, that would not be a defamatory statement, but that's not what he said. What he said was that my client signaled out my client as the person who had tried to unduly influence Mr. Paglia. When Mr. Paglia's lawsuit, and the governor knew or should have known this, the thrust, the crux of the lawsuit by Mr. Paglia was that people pressured him into making a decision before he made his decision in August of 2007, before my client came on the SORB. That is the reason that the case settled, I would suggest, or at least a fair inference that that's the reason the case settled. That didn't have anything to do with my client.
I guess I'm trying to struggle with whether this is a summary judgment issue or a motion to dismiss issue, because the governor certainly has a valid defense, which is, no, I was referring to the Paglia lawsuit, and the Paglia lawsuit said that Ms. Edwards tried to get him to change his mind, and that's a completely fair position. It's not in your complaint. It doesn't say it in your complaint. So I guess my question is this very important discussion about the content of the Paglia lawsuit a summary judgment issue or a motion to dismiss issue?
It should be a summary judgment issue. It's not a motion to dismiss issue, because you're taking all of the facts, as we have alleged, as true with all inferences in our favor. And when you start getting into the kinds of discussion that we have, it's a very valid discussion, obviously, but it's not a discussion to be had with respect to whether or not we've stated a claim.
Well, we can look to your complaint, and I'm trying to understand the logic of your position. Paragraph 59 of your complaint says that the governor's termination of your client was the legally impermissible result of his wrongful personal interest in retaliating against and punishing your client because she placed the best interest of SORB and the public ahead of the governor's personal and political interests and ahead of the personal interests of Governor Patrick's sister and her husband. So that is why you say he fired her, and yet you say that the defamation is that he claimed that she was inappropriately pressuring Mr. Paglia to change his mind, and you say that he knew that she had not done that, and therefore it was defamatory because he knew that she had not inappropriately pressured her, but said that, and I don't understand how that connects with his motive in firing her. What was his motive in firing her if he knew that she had not inappropriately pressured Paglia to change his position?
If I understand your question, Your Honor, we say that Governor Patrick did what he did because he was unhappy with my client's refusal to let, basically, the brother-in-law's case die. That is not inconsistent with our suggestion that although he was unhappy with that, he still knew, or should have known, reckless disregard, that my client had not done what he accused her of doing. He accused her of trying to pressure a person into making a particular decision, a hearing officer. And he did so, and we say that with respect to his statement that that's what she did, that that's a defamatory statement, I don't see it as inconsistent with why he would say something that wasn't true.
Isn't this whole discussion sort of supportive of the view that maybe we need an absolute privilege?
I would suggest no, Your Honor. The absolute privilege simply goes too far. And with respect, and the one point I want to make with respect to a couple of the underpinnings for absolute privilege, with respect to the suggestion that somehow it advances governmental interests and that the governor can perform his tasks as needed. There's nothing about the conditional privilege that interferes with the governor's ability to make decisions. And that's at the heart of the administration of justice, administration of government. The second thing is that I would suggest it's inconsistent to say that we're looking for candor, that is truth-telling, but we're going to harbor statements, protect statements that are made that are untruthful. So that the underpinnings that are set forth in the restatement really don't live up to strict, careful scrutiny of what of those underpinnings. And we've set that forth in our brief.
Thank you.
Thank you very much.